Alright, hello again everybody. Welcome to our next lesson here. This is Proceedings Before a Trial, Part B, 2019 to 2020. Objectives and Standards. You will be able to understand different proceedings before a trial, continuing on with that like we did in our last lesson. And you will be able to identify motions that are made in proceedings before a trial as well. All right, and take a moment there to look at the standards again. Ignore the crazy looking shape here. I'm trying to draw a rectangle, but please take a moment there to look over the standards as well. Okay, and desired result. How are actions used in processes before trials? Okay, sorry, the blue check mark there's a little dark, but how are actions used in processes before trials? I want you to be thinking about some of the steps and some of the actions that take place before trials as well. All right, so preliminary hearing. The screening process used in felony cases, okay, to determine if there is enough evidence for a defendant to stand trial is a preliminary hearing. In our last lesson, we talked a little bit about misdemeanors, which are not as much as serious crimes. Felony cases, obviously more serious crimes like rape, murder, burglary, robbery, things like that, okay? I'm sorry, I always have trouble with that word. But a prosecutor prevents evidence of the crime and that the defendant committed the crime most likely, okay? Excuse me. Now, most states allow a defendant to have a lawyer there to challenge the evidence and to question witnesses as well. Okay, if the judge believes there is enough evidence, if the judge believes there is not enough evidence, my apologies, the case may be dismissed. However, if the judge agrees there is enough evidence, the case then moves to a trial. So this is a stage where the evidence and the testimony are presented before a judge to see if the person should go to a trial or not, okay? All right, and our grand jury here. If a judge does not believe there is enough evidence for a trial, prosecutors may still try for a trial through what is known as a grand jury, okay? And this is a group of people, 16 to 23 people, a little bit of a typo there, but that's okay, determine if there is enough proof to hold a trial. So a group of 16 to 23 people determine there's enough proof to hold a trial. And I apologize if you hear any noise in the background. My kitty cat's running around back there. The defendant, their lawyer, and the judge are not present at this trial, okay? So it's just mainly the prosecutor and the evidence and the testimony, sometimes witness testimony and things like that, and then the grand jury. They don't decide if the person's guilty or innocent. They simply decide if there's enough information or enough proof for the person to go to trial. So if they agree, then an indictment, okay, I want to underline that there for you, sorry, and then an indictment or formal charge, of criminal action is then made against the person. Felony arraignment and pleas. Okay, the defendant is required to appear in court to plead guilty or not guilty once a trial is set. When a defendant pleads guilty, the judge sets a date for sentencing, and we'll be talking about sentencing in our next couple of classes here. But if a defendant pleads guilty to the crime, admits to the crime, then the judge will set a date for sentencing, what their punishment may be. If a defendant pleads not guilty to the charges, then the judge sets a trial date, says, hey, we're going to have this trial, 6 months from now, whatever this date, be back here at that time. Defendants can also plead nolo contender, which means they do not admit guilt, but they do not contest the charge. It's a little tricky. So the person is basically saying, I'm not saying I did it, but I'm also saying that there's enough proof there to say I did it. So a little tricky to understand. But what that basically means is the person, doesn't have really the, the problem of having it on their record permanently that, that they pled guilty to something. A judge also asks the defendant at a felony arraignment what they prefer for a trial. There's a couple of different things that can take place, okay? They can have a jury trial, which is a trial by a jury of their peers, which is, I think I've mentioned to some of you already that I served on a jury earlier in 2019, in January and February 2019. So you can have a jury trial, and you can take your chances with members of the public, and that was kind of interesting being on a member of a jury. And then you can also have a bench trial, and a bench trial is when a trial where the judge hears the evidence and decides the case. There's no jury. You simply have a judge listen to the evidence and the testimony and make the decision then. Excuse me. So there are two different ways that trials can take place: a jury trial and a bench trial. Pre-trial motions, okay? Motions made during the preliminary stages of a trial look for the court to take action in what are known as pre-trial motions, okay? A lot of times, a defendant and their lawyer may ask the court, to dismiss the changes in different ways, okay? They can ask the court to dismiss the charges, in different ways. Couple of them are, and here are some of the motions here for you. Number one, motion for the discovery of evidence. This is a request by the defendant to examine evidence that was discovered by the prosecution, okay, to see what you're being charged with, who said something about you, or, what evidence do they have against you. Number two, a motion for a continuance. This means that either side can seek more time to prepare for the case. They might go and say, Your Honor, I'd like to ask for a motion of continuance. I need more time to prepare, or new evidence came forward and I need time to prepare. And again, the judge can allow or, deny these motions. Number three, motion for a change of venue. Request to change the location of the trial due to community hostility, for the convenience of the witness, or for other reasons, okay? Sometimes, a crime might take place in a certain area and it's well known and all over the news, and we don't want the jury to be biased or be swayed by the news or newspapers or information, things like that. So they might move the trial to another part of the state or another part of the community where people may or may not know that person as well. That way the person gets a fair trial. And then number four is a motion to suppress evidence, okay? Request that certain evidence not be allowed in the trial, and this is the most controversial motion because obviously both sides want to use the evidence that they have. Both sides also want to prevent the other side from using certain evidence that might sway the jury or a judge. So motion to suppress evidence is the most controversial motion to not allow certain evidence in a trial. Okay, the exclusionary rule. We've already talked a little bit about this in previous lessons, but people are protected from unreasonable search and seizures under the Fourth Amendment to the United States Constitution, okay? And I know it's a little small to read, so I do apologize for that. Evidence that is seized without proper legal authority may be dismissed under the exclusionary rule. Defense lawyers typically try to get evidence dismissed under the exclusionary rule, exclusionary rule in trials. And this is very controversial, and some people believe this allows criminals a quote-unquote loophole in the justice system, right? Saying, well, they committed the crime, but because the evidence wasn't seized legally, or the bloody knife, or, the gun in the backyard, or whatever wasn't seized legally, it can't be used. And some people it allows people to get off scot-free pretty much from, the crime they committed. Excuse me. Others who support the exclusionary rule say that judicial integrity and deterrence allow for fairness. Okay, two words here. Judicial integrity is the idea that judges should not allow law breaking by the police. So we shouldn't allow police just to kind of walk into our homes and take evidence without our permission or without proof that they need that evidence, right? We want to be protected a little bit from the government and from the police a little bit. And deterrence. Police will be less likely to violate civil rights if they know the courts will throw out evidence. So you can see some police officers here or detectives look like they've collected some evidence, yellow tape there on the bags, collected something from a crime scene or something like that, or from a house or property. So, I'm sure they probably hopefully attained this legally with warrants and things like that. Plea bargaining. Okay, plea bargaining. Most cases, about 90% never go to trial. That might be surprising for you to learn, but most cases never go to trial. Defendants in a criminal case typically plead guilty before a trial, or they look for something called plea bargaining, okay? Minor cases such as traffic violations, this is like if you get pulled over by a police officer, he or she gives you a ticket, I'll admit that I've been pulled over by a police officer a couple of times, and had to get a ticket and things like that, and they say, here's your ticket, if you agree to this, or that you were speeding or you ran a red light or whatever, you sign on the back of it and you pay the fine and you mail it in, and that's pretty much you admitting your guilt. Now you can always challenge a traffic ticket, which I've done as well too, but most times most people just pay the ticket and send it back, and they plead guilty to it. They don't go to jail or anything like that. They just pay the fine and move on with their lives. Okay. So typically typically involves the person signing a form, admitting their guilt, and paying a fine. Okay. Defendants in major cases usually work with their lawyers to negotiate on agreement on their behalf, known as plea bargaining. Okay. Now, plea bargaining, both the prosecution and the defense will work to come to a decision that benefits both sides, okay? Typically, the defense will push for a lower sentence or less severe punishment, while the prosecution may look for higher sentence or harsher punishment, okay? Once a plea deal is made, the judge will make sure that the defendant or the person charged with the crime agrees to the agreement as well. Say, hey, do you agree to the stipulations or what's been discussed here? And typically the defendant will say, yes, I agree to, do 30 days in jail and, do 180 days of community service or something like that, instead of going to jail for 5 years or something like that, something like that. All right, closure. Okay, once again, how are actions used in processes before trials? Think about some of the different things we talked about here, some of the actions that can take place before a trial, right? Preliminary hearings, grand juries, pretrial motions, also the exclusionary rule, how does that play in the trials, and then also plea bargaining. All right, I want you to be thinking about all those things and try to explain some of the actions that are used in processes before a trial may take place. All right, and that'll help you answer your questions. Please try your best on the questions that follow and let me know if you have any questions or concerns, and I hope to talk to y'all soon. Take care, everybody. Bye-bye.